Good afternoon. Thank you for joining us today. It's time to talk real estate with Laura Bramnick from TalkRealEstateAZ.com. Laura is an attorney specializing in real estate. She is also a real estate agent, so it's a twofer.
It's a twofer.
Which is a great combination.
Yes, it is.
You help folks with negotiating residential, commercial, land transactions. And you can actually provide legal advice on many of these real estate deals.
Yes.
And sometimes it doesn't cost any more.
That's right. So definitely call me and see if your situation applies in the way that I can be paid through the commission, which would cover my legal fees.
And it's so much better to have a real estate attorney than just a simple real estate agent, in case anything comes up.
Yeah, you know, real estate agents haven't gone to law school. They are trained in certain ways to draft contracts, but there's many things that come up that if they haven't seen before, they may not realize it's a legal issue that can hurt their client.
And there are a lot of issues in real estate that can be confusing. Here's one for you. Assignments. And
Yes.
we're basically talking about mortgages here.
Assignments of mortgages, correct.
This can get to be a complicated issue. First of all, let's explain what is an assignment.
An assignment is a document that states, in the case of a mortgage, that your mortgage has been transferred from the original or current lender or borrower to a third party. So there's another party involved that has rights that are equal to one of the original two parties.
And this actually happens quite frequently. Lenders tend to assign over to other lenders, or
Yes.
yeah,
Loans are transferred and sold all the time.
yeah.
And I have clients who call me that say, you know, I've had 10 different mortgage companies that I've paid over the last 25 years. You know, so, and then, you know, during the crash, a lot of mortgage companies went out of business and your loan was taken over by another company or bank. So it's very common that loans get sold and transferred, and you don't want to get confused. It's legal, but there has to be in a document called an assignment that's recorded in the county where your deed and mortgage are recorded.
Well, now this is actually quite important, because if you go to make a mortgage payment, you want to make sure it goes to the right party.
And many times you don't get notified of your new lender, your new account number, or your new lender's contact information. In other words, where to send your payment.
Mm-hmm.
Many times you don't get notified till after your payment is due. So the federal government has come up, this is not new, but they came up with a solution, meaning that no negative credit or no collection activities of any kind can occur for 60 days. So you still owe the money, but if you're not notified in time, you won't be late, you won't be charged a late fee, and you have a 60-day grace period.
I bet not everybody's aware of that.
Under federal law, people get very
Yeah.
people get nervous. A lot of people pay their mortgage. They consider that a necessity. They pay it before they pay other bills. And so it's very important. And once your old lender tells you they've transferred, usually they send you a letter and they give you a date that they will not accept payments anymore.
Now, the lender can make an assignment. Can the borrower also make an assignment?
The answer to that is yes, but not in every case. A borrower assignment would be an assumption. In other words, you want to sell your house and your buyer assumes your mortgage. So most conventional mortgages do not permit assumptions. However, FHA loans permit assumptions, and if you have a private lender, they may permit assumptions. So that's what an assignment would be in the case of a borrower.
An assignment would really be an assumption, but you got to be a little bit careful about that, don't you?
Oh yeah, because the assumption or the assignment, if you're the borrower, you can one of two things can happen. You can be released from the obligation of that loan, or you could be on the hook for the obligation for that loan. And like on commercial loans, if you want somebody to take over your payments, let's say because they're buying your building,
Okay.
Most commercial loans don't let you off the hook.
You really need to know that before you
Yes.
enter into that agreement.
You need to know what it says. Now, FHA loans, the borrower, the buyer, the new borrower has to qualify. Once they qualify, you are not liable, once the assumption goes through with FHA. So every lender is different. Don't assume that an assignment or an assumption all have the same terms.
And I would imagine there are a lot of private party transactions where this would come into play.
Definitely. A lot of private party transactions with land, commercial. If your home's paid off, you don't have a lender, you can sell it and become the lender under certain circumstances.
Mhm.
There are other federal laws called Dodd-Frank that have come into play that have restrictions, but they don't prohibit you from carrying back the loan. Also, it's not uncommon, let's say before Dodd-Frank, where you sold your home, maybe you're elderly now, and you took a carryback because you wanted the income.
Right.
Maybe you got a good rate,
Sure.
return on your money, better than you get in a bank. Now, maybe you've died. Now your spouse doesn't want to deal with the payments. So your spouse could sell your loan and assign your rights under the loan to a third party.
Mm-hmm.
And so you want to make sure in that circumstance that there are actually two assignments. There's an assignment of the lien, and there's an assignment of the actual promissory note. So again, you want to make sure you get proper legal advice so that you're protected.
And as always, you got to record it.
You've got in the case of a lien, yes. In the case of assigning the promissory note, it's usually not. But you want to refer to that, you want to refer to both assignments in both documents.
And what about the note and the relationship to the assignment?
Yes. When you assign the note, it indicates that you've also assigned the deed of trust, which is the lien. And when you assign the lien, which gets recorded, you also indicate in that paperwork that there's a corresponding note.
There are a lot of folks, I'm sure, who have over the years done some private party stuff.
Yes.
And they, as you say, they do it for the income or whatever it may be.
Right.
And they probably think, oh, I can do this.
Correct.
I've done some real estate deals over the years, and no big deal. But you get it wrong, you got a big headache. It's smart to just get it right in the first place, and that's where I think you can provide a tremendous service, Laura.
Yeah, it comes up. It's not that as infrequent as people would think.
I'm sure. Laura Bramnick at talkrealestateaz.com, talkrealestateaz.com, or Laura's phone is 480-624-2705, 480-624-2705, talkrealestateaz.com. Very important, good info. Thank you, Laura.
Thanks, Sinclair.